Good morning, ladies and gentlemen. I welcome you to the 2841st meeting of the Human Rights Committee, where we will continue considering the second periodic report of Kuwait. Before I give the floor to Ambassador Razuki, I will give the floor first to Ms. Fox to make an announcement. May we have some order, please? Thank you.
Thank you, Madam Chair. I'd just like to make one small announcement and change to the programme of work, which is important for the public. It relates to the consideration of the follow-up report on concluding observations. And at the request of the rapporteur on follow-up to concluding observations, who wishes to meet with more states parties between now and the end of the session, we are postponing the consideration of the follow-up report until the last week of the session. So on Monday, the 24th of October, when you were supposed to be considering the progress report of the Special Rapporteur on follow-up to concluding observations, you will now be considering communications. So you will have communications on Monday morning, the 24th of October, from 10 o'clock until 12. And then the consideration of the report on follow-up to concluding observations will take place on Monday, the 31st of October. So that's the last Monday of the session. And it will commence at 3 o'clock, so at 15 hours, until 4:30. And then you will continue with communications at approximately 4:30. That session will obviously be a public session. So the session on the 31st of October at 3 o'clock is a public meeting, and it concerns the follow-up to concluding observations. So I hope that's clear. The new programme of work is on our website, and it will be distributed also to the members later on today. Thank you.
Thank you. I now give the floor to Ambassador Razuki to continue with the responses from yesterday afternoon. Thank you.
Thank you, Madam Chairman. Yesterday, frankly, I was very clear. I explained the definition exactly of stateless, in which we have certain, position, in which definition, my own definition is different, and then was very clear. I want now to give my colleagues to explain that very elaboratively, but frankly, I want as much as possible to be precise concerning the questions which was addressed, which is why they are not giving them the certain sovereignty rights, which we think is very, very important, and that's the nationality. And what about our relationship with the with the countries surrounding us, that we are negotiating with them to see exactly how we can solve these problems? Also, how there were some questions about why they are not coming back again, and the consequences of that. And I think Doctor, you will answer it very well. Mohammed, you can explain that.
Thank you, sir. Regarding the question put to us regarding illegal residents or what the entitlement illegal residents, it was defined in the decree 467, and it is based on the law for the residents of aliens. of 1959, which does not provide official residence to foreigners unless they have a valid passport. Therefore, this title was given to people who do not have documents and are residing in the country with legal documents. Those who live in the country or reside in the country illegally or because they have remained in the country after having hidden their documents. Regarding the question on the measures that have to be taken in order to be granted nationality, we would like to clarify here that the issue of granting Kuwaiti nationality is a sovereign right of the state, which is governed by the law on nationality, number 15 of 1959, and we have to take into account the best interest of the nation. As to the question of the expert regarding whether there was a plan to provide this category of people a Kuwaiti nationality in view of the fact that they have remained in the country for such a long time, we would like to clarify that by virtue of Decree 460/2010 regarding the setting up of the Central Authority for Illegal Residents, a period of 5 years was determined during which the status of these people has to be settled. All the cases of application for nationality will be settled and will be discussed, and we shall be cooperating with neighboring countries in order to find a solution to those who are illegally residing in Kuwait. We have to clarify that the Central Authority plans to coordinate with the countries in the region and who are also facing the same situation in order to exchange experiences and best practices. Regarding the question on whether there were any steps or measures in order to allow this category of people to return to Kuwait, we would like to clarify that we can consider their return in coordination with the competent authorities. In only one case, if they have left the country legally with a valid passport, and if it is proven that these persons have been registered with the Central Authority as illegal residents. 3, that they have not left the country because they had committed a crime or because they have avoided the implementation of a judgment against them. 4, to prove that they are not nationals of another neighboring country. Thank you, sir.
In the police, and then he gave us, this answer, which I think. If we need statistics more, we will. Unfortunately, Madam Chairperson, that the statistics we have in Arabic, but we'll try as much as possible. I told my colleagues that we have to do more in translation and provide them in English, and we will not let other, translate for other people. We will try our best that the translation will be available. Frankly, now, I think there are some questions about the definition of Iman. Sorry, Iman. You can continue, Iman. But as for Iman, we don't have that much time, huh?
Okay. Shukran.
Thank you, Madam Chairperson. You want statistics regarding the services provided to this category of people and the benefits and privileges awarded to them by virtue of Decree 409/2011. Many benefits and services have been provided to this category of persons. These benefits were in fact provided before the decree was issued. The decree just came to confirm the legality of these benefits. They are provided with health care and education, and they have become exempt from certain taxes. The charitable fund for healthcare provided healthcare to those who needed healthcare from this category. After the decree was issued, these services are provided to all illegal residents in the country. And as to the children of Kuwaiti women, they are allowed to enroll in Kuwaiti universities, although there is only one government public university and it does not have the capacity to absorb even Kuwaiti nationals. It was allowed for the students from this category to enroll in these universities. In the 2011, 156 students were enrolled in the university. Regarding civil documentation, they were granted birth certificates, death certificates, marriage licenses, and divorce certificates. These documents were granted to them in the past before the decree was issued, but they were conditioned on the fact that they should prove their nationality. These documents are now granted to them without having to prove their nationality of origin. And regarding birth certificates, the number of birth certificates issued since April amounts to around 11,000 birth certificates, and these numbers are steadily increasing. The number of death certificates issued was around 520 birth certificates. As to marriage licenses and divorce certificates, they amount to around 1,244. Regarding driving licenses issued to this category of persons amounts to around 2,064 licenses. Regarding employment in the public sector as well as the private sector, they are entitled to seek jobs in both sectors, although it is well known that the government sectors are already employing persons from this category. They amount to around 7,000 employees in the public sector. Of course, they are also issued with ration cards. Thank you.
Yes.
A question about, the definition of torture, and then there was criminalizing torture, and then there is a difference in the numbers which had been in the annex and between the reports. I have, frankly, in CAT, when I represented Kuwait report, I gave a very extensive definition about exactly, we have the laws, we have everything. Because of the short of time, I have only 5 minutes. What we have said in CAT is very well defined. We have laws which criminalize torture, but at the same time, that to take the proper definition of what's the treaty itself, we are discussing it now within a small group, within the state of Kuwait, to find a definition exactly matches. And I have that commitment, and I made that commitment in CAT, that the definition of torture will be as it is in the treaty itself. I will accept it. I have no problem about that. And that will be clear and will be defined. Though we have other groups saying exactly that what we have from laws to criminalize torture, you see, it complements it. I said, no, we want, and I made it in CAT, that we would like the same definition, and I made that commitment, and I hope that the special group of legal experts, they will put the same definition which they have in CAT as a part of a Kuwaiti law. So I will not extend more. I was going to give it to the concerning the gap in the numbers which has been given by certain. I think Mohammed, quickly, because we have less than 3-4 minutes, because I have to give other things. Just why the gap is not there.
شكرا سعد سفير.
Thank you, Madam. Regarding the statistics that were contained in the report, they refer to the cases which were brought before against the police, accusing them of torture. And I shall refer to the judgments that were issued against them. Certain cases are still pending. Thank you.
The capital punishments. Capital punishment, absolutely, it's part of our religion, part of Sharia Islamiyah. But when we look, as I had told you, concerning the polygamy, that we developed in a way where we are less and less going in that direction, frankly. And it will take tremendous time in order to commit a person towards capital punishment. It's not easy, especially when you develop certain understanding, certain education, certain courts, a lot of issues we have not, frankly. So capital punishment, I think, Zakaria, you can tell us exactly if you have some statistics when the last time. Khalil, the last time we have concerning capital punishment. I think it was since 1907. Huh? 2007, yeah.
Good morning to you, Madam. Regarding capital punishment, since 2007 until now, no capital punishment sentence has been executed. There are a number of Kuwaitis who are on death row. There are 52 cases who are on death row. 7 Kuwaitis, 11 Pakistani, 10 Bengalis, 6 Egyptians, 1 Iranian, 1 Syrian, 1 Filipino, and 2 Biduns. As to women who are on death row, there is 1 Kuwaiti woman, 1 Ethiopian, 1 Sri Lankan. I just wanted to allude to one point, Madam. The death sentence cannot be executed unless His Majesty the Emir endorses it. And since 2007 until today, no death sentences have been executed. Thank you.
There is no discriminatory, not whatsoever, concerning a person or the person. I will not interfere to say that we are, because he is Kuwaiti, this one not Kuwaiti, this is a ruling family, this is not ruling family. Absolutely not. Does not go in our principles, whether we are as a Muslims or we are a part of this international community. We reject whoever, I mean, non-governmental organization, with respect with them, whatever, never, never. We have any discriminatory matters in where we are judging a person. We judge the person on his deeds, on what he committed. And the last time that we, frankly, as I said in 2007, we never, and we try. We give the issue is a tremendous time in order that we can be committed. Everybody is equal in front of the law. Everybody, including me as an ambassador. I have no privileges. I am as equal as anybody else in Kuwait. If I commit a crime, I have to go to the law. And that's not only, anybody else. No rich, no poor. No ruler, no worker. All of us under the law. Thank you, Madam Chairperson. I will not indulge more than that.
Thank you, Mr. Ambassador. I shall now give the floor to members of the committee for follow-up questions. I give the floor first to Mr. Telling.
Thank you, Madam Chair. I'm grateful for the answers given yesterday and today. And let me first of all say that a topic that was not raised, but raised by the Ambassador, gives me reason to reflect on the following. If tax exemption was a human right, Kuwait would get top grades. When it comes to other issues, I'm not so certain. Let me first say that I'm grateful for the figures given regarding the death penalty and the figures are those in death row and the breakdown in nationality. However, I would be grateful if we could be also supplied with the crimes that they were sentenced to death for. It doesn't have to be during the session. That could be provided to us in writing within the prescribed 48-hour period. I think on issue number 9, I'm fairly satisfied. Suffice it to say, and I'm glad that the Ambassador referred to the findings of the Committee Against Torture, which is a very recent recommendation as of June this year. And let it just be said that I certainly support the recommendations therein, namely that Kuwait should incorporate the definition of torture into its domestic law and also establish a separate and independent mechanism for investigating of allegations of torture. Regarding the statistics, I'm grateful to see them coming. Let me just add then, it would be helpful if we could add the numbers also for prison staff. The figures we now have are only for police officers being indicted and tried. So that, if that could be supplemented, I would be most grateful. Moving then to issue number 10, we got an answer yesterday, but the issue on the number of those in pre-trial detention and also the average length of pre-trial detention remains outstanding. When it comes to issue 11, I listened very carefully, and I think no one has touched upon that. So my question regarding those who were convicted in military tribunals in 91 and what is being done with them, that still remains. Moving then to issue 17, the judiciary. We got an answer yesterday on the foreign component. It was you, I believe, Mr. Ambassador, who answered that. And the way I understood it was that the fact that most of the foreign judges were seconded from another country made the question of their independence such that no critical voice could be raised against it. Well, I offered the opposite. If you have part of your judiciary people who are seconded from another country, you should say the more interest to safeguard the independence of the judiciary, because they would then be subject to two heads, one of their own nationality outside the country, and then whatever deficiencies there are within the country. So that answer certainly did not satisfy me. And the issue of the Supreme Judiciary Council and its dependency on the Ministry of Justice is an issue which I still would like to have a clarification, because that is a concern to me. And let me also say that this is not something that is unique to Kuwait. We have the same system in many countries where there is a link to the executive which is unwanted. So that comes under scrutiny in many of the instances here. Finally, issue 18, i.e. the Islamic legal provision saying that a woman counts for half of a man in giving testimony, was not yet answered, unless, Mr. Ambassador, and I listened very carefully, and I appreciated your comparative analysis as to the core values of the human rights documents and Islam, whereby you seem to say that they are equated, so they shouldn't be in a tension between them. Well, again, I have to disagree, and this goes not only to issue 18, but also to issue 8, and I believe issue 1, which was raised by a colleague, namely that the covenant itself, it's a legal instrument, and it doesn't make any exception for any divine spirits, wherever they come from, be they Christian or Islam or some other religion. The fact is that the covenant reigns supreme and is not second to any other principle. And that's why it's obviously of a concern to us when we find on issues like capital punishment and on this issue of family law, procedural law, that there is a mere reference that the Islamic law makes it all right, as it were. That is, in essence, putting the covenant in an inferior position to the tenets of a religion. And that, sir, I offer, is not acceptable. Thank you, Madam.
Thank you, Mr. Tellin. Mr. Amo. Mr. Amo, you have the floor.
Shukran.
Thank you, Madam Chairperson. Since I am taking the floor for the first time, I wish to warmly welcome this excellent Kuwaiti delegation headed by His Excellency the Ambassador. I have noted that the delegation is also composed of 6 women, and this is extremely encouraging in view of the status of women in Kuwait. I should like to concentrate on 2 connecting issues. The first issue relates to the interpretative declaration and the reservation on Article 3 and Article 23. Regarding Article 3, Article 3 does not accept any discrimination between men and women. Non-discrimination is a general rule of international law, and what I am wondering whether this reservation is acceptable and admissible. I wish to request the delegation to provide us with an opinion on this matter. The second issue I would like to raise relates to the status of women in general and in particular polygamy. Reservations to Articles 3 and 23 is based on the requirements of Islamic law. However, we would like to recall that this committee, in its interpretation of Article 3, considers that in the case of polygamy, that polygamy is a violation of the dignity of women particularly since the preamble of the covenant enshrines the need to safeguard dignity of women. Therefore, we cannot accept discrimination between men and women as it violates the covenant. We can justify the status of women by invoking Islamic law. However, I would like to say that Islamic law should not be a burden. It should be a means to protect Muslims and safeguard their rights. And we must distinguish between what is contained in the Holy Quran and what is contained in the provisions that were drawn up by men. These provisions must be flexible. What has been made by man can be, what has been done by man can be undone by man as well. Of course, the basis and the foundation is the Quran. But the Quran could not be an excuse or a justification for polygamy. And I am saying this because I myself am a Muslim and Islamic law is important for me. The requirements of Islamic law and the interpretation of the clergy is quite clear. God Almighty has said that men can marry 2, 3, or 4 persons. However, if you fear that you will not be able to do them all justice, then you must not marry more than one. If we read this verse, we see that there is a condition. If you fear that you cannot do them all justice, then you should abstain. It is merely the fear that you may not do them all justice that should prevent the man from marrying more than one. Therefore, any man with a good conscience should ask himself before marrying more than one person whether he will be able to be just with all of them. And then afterwards, the verse says, and you will not be able to do them all justice. And Zamakhshari said that therefore this last phrase, and you will not do them all justice, prevents Muslim men from marrying more than one person. That is, even a man, if a man claims that he will be able to be just with all of them, it is in human nature that he will not be able to be fair to them all. Therefore, the Quran may not be an excuse and may not be a justification for polygamy. The Islamic jurists have interpreted the Quran well, and we must not claim that Islam allows for things that are contrary to Islamic teachings. This justification may not be allowed and is not admissible. It is not right. I conclude that discrimination between men and women is not right in view of Islamic law, and therefore is a violation of the covenant. I believe that the state of Kuwait should reconsider its position Many other countries have done so. This is not new. And for us, the state of Kuwait should give the covenant precedence. Thank you.
Thank you, Mr. Amo. I give the floor to Mr. Newman.
Thank you, Madam Chair. I thank the distinguished delegation for all the answers that they have given, both to the questions that I asked and the questions that my colleagues have asked. I asked many questions. We asked many questions. It is understandable that some of them may have gotten lost in the quantity. So I just briefly want to raise two small points and request quick answers, if possible, that I raised yesterday that I don't believe I heard an answer to. The two small points relate to detention pending deportation. One of the questions was whether there is a maximum period for detention pending deportation. It has been put to us that some people have been stateless, have been held for deportation, that it has been difficult to arrange for their deportation, and that years have gone by where they have remained in detention pending deportation. I wanted to ask not so much whether that fact occurred, but whether the law sets a limit on the amount of time that someone can be held pending deportation. And the second question related to that was the question of resort to the courts. Are people who are detained for deportation able to address themselves to the courts for a judicial ruling on whether the detention is lawful? Thank you.
Thank you, Mr. Newman. I give the floor to Mr. Fatala.
شكرا السيد الرئيس. أود في البداية أن أتقدم بخالص الشكر للعرض المفصل الذي تقدم.
Thank you very much, Chair. With regards, we would like to thank you very much for the explanations given by Kuwait. I'd like to thank the Ambassador, His Excellency, and the Head of Delegation from Kuwait. I would like to thank him for having given such clear explanations and for having answered the questions put to him by the experts. He explained to us a certain number of issues, but I have two further questions to put, and they are the following. First of all, I have a question relating to the bidoons, the undocumented residents in Kuwait. Are they really called bidoon because they do not have a nationality? That's my first question. As far as we've understood from the responses provided yesterday, that the bidoons are the illegal, unlawful residents in Kuwait. Now, for us to better understand the situation and to better assimilate, digest this phenomenon, for all of us to understand it, could you tell us who the bidoons are exactly? Because it's in our benefit, it will be in our benefit to understand who they are, these undocumented people. From what I've understood so far from your replies, I understand that these people who've arrived in Kuwait in the 50s and 60s, who were undocumented, and they came to benefit from the well-being, the enrichment of Kuwait, which occurred following the oil exploitation in the country. And apparently some of them hid the passports to hide, to conceal where they were from, so they do not have a passport, they can't be thus registered, and they became, to a certain extent, unlawful or illegal residents in the state of Kuwait. So there is a combination of factors at play here. They are people who do not have a passport, they can't prove where they came from, they can't prove their identity, therefore they become illegal residents. Now, if I have understood this rightly, please confirm it. And I have a subsidiary question related to that, namely, these bidoons, these undocumented persons who have been, for all intents and purposes, for 50 years in Kuwait. What is the laws that govern their residence? Are they entitled to nationality by law? Is there a law that permits the naturalization of these undocumented bidoon people? There are two systems in the world related to this. There is the nationality granted on the basis of where people reside, and and when people have been living for long enough on the territory, and you add such of other conditions, a marriage to a citizen of the country, and other countries set the length of stay on the country to set nationality. So can you tell us exactly what the issue of the Bedouins is all about? I have another matter to raise with you, and that has to do with what was said by Mr. Amor from Tunisia. I agree with him for the first part of what he said, but I don't quite... sorry, I agree with the second part, but not quite the first part of what he said earlier on. There is a Quran shurat which makes polygamy possible, lawful. My colleague made a comment earlier on, and he said we must absolutely be just and fair between the 4 wives. Now, we're not specialists in the area of Quranic exegesis, of the interpretation of the Sharia. Sharia law is a type of law. The word Sharia comes from tashriya, which means law. So it is a form of Quranic law, what we're talking about here. But within my intellectual limits, and as far as I understand Quranic laws, Sharia is a law, and some countries, in their legislative framework, they inspire the provisions of the laws from Sharia law. Countries can do whatever they want in terms of enactment of legislation, but every country must abide by their commitments under the covenant and under other international agreements. And I agree with my colleague, Mr. Amor from Tunisia. The second part of the Shurat was forgotten. And this part says, you shall never be... It's impossible to treat all your wives equally. That's what the second part says. So the meaning of the Shurat is clear. We're not here interpreting the Sharia, but at least as from the legal point of view, from an objective point of view, when we are told you will never be able to treat all your 4 wives equally, quote unquote, well, then it is clear, as has been said by my colleague, Mr. Amor from Tunisia, it is clear that, and I'm speaking here of polygamy, that is, it is clear that the law must contain provisions that limit the number of wives men can have. And as we said before, it is Sharia that defines or does not define, as the case may be, the number of wives.
Thank you, Mr. Fatala. I give the floor to Senator now.
Thank you, Madam Chairperson, and I too thank the delegation for the responses we received. Just picking up briefly on the issue of the death penalty, the last issue raised by the distinguished head of the delegation. Could I ask for slightly more information than that sought by Mr. Tellin? Mr. Tellin wanted to know what offences the 53 on death row were convicted of. I would like to know what offences since 2000 anybody sentenced to death have been convicted of. In other words, for the whole reporting period, I would like to know how many people have been sentenced to death, how many people have been executed, how many people have been executed and for what offences, in addition to the offences for the 53. Of course, I'm very pleased to hear that there have been no executions since 2007, and if that execution in 2007 is the last execution in Kuwait, that would be a very, very nice thing to learn by the time we get to the next report of the distinguished delegation. I was grateful for the answer relating to the periods of police detention after arrest, but it didn't quite respond to what I was looking for, and maybe I should make clear where the committee is coming from. And where the committee is coming from is that it considers that people should be, one, out of the hands of the police within by the time they've appeared before a judge, and at the time they appear before a judge should be no more than 48 hours in principle. I'm not clear still, and my question was about periods. I'm not clear at what point it is possible to say that is the maximum period a person can be held in police custody. When do they appear before a judge? When do they get access to a lawyer? What is the maximum period after arrest or detention that a person gets access to a legal counsel, gets to appear before a judge, gets out of the hands of the arresting and investigating authorities? These are questions of pure timing. Needless to say, maybe the member of the delegation assumed we'd done more homework than we've been able to do. I'm not familiar with the criminal code or the criminal procedure code of Kuwait, so we need that information explained to us in ordinary terms. Yes. The next issue, so that related to issue number 10. The next is issue number 17, and the question of women in the judiciary. Again, I listened attentively to the answer. I had asked a question about women judges, and I got an answer saying that there were women in the judiciary, but other aspects of the answer did tend to suggest that there were, in fact, no women judges, as we had been informed. There was a reference to criteria for access to the judiciary. 5 criteria were mentioned, but they weren't specifically explained. I'd be interested to know what of the criteria are relevant to the fact that women are not in fact appointed as judges, if I understand correctly, that women are not appointed as judges. On the issue of issue 18, the women's testimony issue, actually I did think I heard a response from the delegation, a reference to the Sharia, of course, and a reference to the fact that for some purposes, that those which are in the women's domain, a concept which is alien to the Covenant, women's testimony would be equal to that of a man, which no doubt is a great relief. I would point out that Article 14, which is the one where this issue comes up, is not an article in respect of which Kuwait has a reservation. So there's no question that Article 14 has to be applicable entirely. I would also point out that Article 26 is also one that, in respect of which Kuwait does not have a reservation, all persons equal before the law. No discrimination on grounds such as race, colour, sex, language, religion, and so on. No reservations there. So again, this is an issue that is squarely within the Covenant. I leave aside the issue of whether or not even the Kuwaiti reservation is compatible with the Covenant. I note that the preamble to the Covenant implicitly quotes the Charter of the United Nations. The Charter of the United Nations is very clear that there can be human rights have to be respected for all without distinction as to race, sex, language, or religion. I don't believe Kuwait has a reservation to the UN Charter, and anyway, as Mr. Amour suggests, the UN Charter probably reflects peremptory international law, which, if it's the case, would make the reservation not applicable anyway. But equally, I haven't heard the delegation invoke the reservation. So the question is, clearly anything that would exclude a woman's testimony or put it on a lesser par with that of a man just seems to have no protection under the Covenant. I'm not going to get into the issue of Sharia or non-Sharia, religion or non-religion, and certainly it would be inappropriate from somebody from outside that belief system. What I'm interested in is, as Mr. Fatala indicated, what I'm interested in is Kuwait's law and the extent to which Kuwait's law, in theory or in practice, is or is not compatible with the Covenant. And on its face, in those two respects, that would, and others that have been discussed and will be discussed, that would appear not to be the case. On excuse me. Finally, an issue that I didn't ask a question about, but the issue of the question of the rights of foreigners and others to various important services. I was impressed by the delegation's statement that that there are free hospital services for all who need them. And this is very encouraging. An NGO did come up to me afterwards, an NGO from inside the medical system, who raised the problem that, in fact, there are small payments that can be required of people who go to hospital, €5, for example. And €5 isn't very much probably for most of us and probably for most Kuwaitis, but maybe for some of the migrant labor in Kuwait, but for people who need quite a lot of attention and who maybe, I'm told, get not more than €100 per month, maybe then it does make medical services a little harder to access by people in that situation. I'd be interested in any comment that the delegation would care to offer in respect of that particular dimension. And finally, Madam Chairperson, the issue of marital rape. I certainly don't want to be too judgmental on this one, since it took my own country till very recently to accept that rape within marriage was the offence of rape. Of course, it always was an offence. It was the offence of assault. Unwanted sexual activity would have been the offence of assault. But it took a judgment of the highest court of the UK about 15, 20 years ago that led to an acceptance that forced sexual intercourse, even within marriage, was rape. I heard in the response on that issue that normal marital relations are legal, and I suppose the implication is that normal marital relations include coerced sexual intercourse within marriage. I would like to think that while it might not be rape in the state party, it would still be another offence against the dignity of the person subject to that coerced sexual intercourse. And I'd appreciate some clarification on that issue too. Thank you very much, Madam Chairperson. Thanks to the delegation for the past answers and for the ones which we anticipate.
Thank you, Sir Nigel. I give the floor to Mr. Lala.
Thank you very much, Madam Chair. Let me join my colleagues, first of all, in very briefly but very warmly welcoming the most able delegation from Kuwait, headed by distinguished ambassador. I'm very grateful for the answers given, and I quite appreciated the sense of humor of the ambassador in answering some of our questions. It lightens what is otherwise perhaps too serious discussion. But of course, having said this, I must come to one very serious concern. In the year 2000, that's 11 years ago, we did the same exercise with Kuwait, and we adopted concluding observations. And these concluding observations are not just done for the sake of doing them. We expect states parties to pay attention to them, and also I will quote, I will refer to them as they are in documents CCPR CO/69 KWT of the 27th of July 2000. I would refer in particular to paragraph 4 and paragraph 26. What did we say in paragraph 4? In paragraph 4, we dealt with the interpretative declarations and reservation of Kuwait to Articles 2, 3, and 23, broadly stated as being only to apply in Kuwait within the limits set by Kuwaiti law. This is very broad. Now, Article 2 and Article 26 and Article 3, as Sir Nigel just pointed out, are basic principles of human rights, and they are supposed to govern the conduct of states parties, whether in their legislative capacity, their executive capacity, or their judicial organs. These are matters which are so fundamental that they cannot be derogated from except within the terms of the covenant. And we did say here that, in paragraph 4, that according to our interpretation of the covenant, these were contrary to the purpose and object of the covenant as we interpret it within the terms of the Vienna Convention on the Law of Treaties. When the Human Rights Committee deals with interpretations of the covenant, it is considered, even by the International Court of Justice, as being a very authoritative pronouncement of what the covenant means. You will be familiar with the judgments of the International Court in the Israeli wall case, where the court extensively referred to the findings of the committee and the law as interpreted by the committee. And more recently, last year, I think, in the Diallo case, the International Court of Justice again adopted the same view as to the competence and correctness of the principles as interpreted by the Human Rights Committee. In our view, and it must be repeated this time again, 11 years afterwards, that these supposed declarations and reservations are without any legal effect. And this is why we very politely asked Kuwait to formally withdraw these reservations. And in our concluding observations, we said in paragraph 26, we had this request. In the second sentence, we said the committee urges the state party to make available to the public the text of the state party's initial report together with the present concluding observations. I will ask two practical questions. Was this done? Was it made known to the public? Was the question of the reservation discussed at all in Parliament, within any public forum, or even within the close advisors of the leaders of the country? If it was not, we would urge you to do this, even though 11 years have passed. These touch very basic things. We have been talking about them, and this morning, Mr. Amor, Mr. Fatala, Sir Nigel have talked about the range of unacceptable derogations which your reservations might tend to create. Not only with regard to women, but with regard to Bedouins and other people in Kuwait. So I will end my intervention here on this single point, which I consider most important. Thank you very much.
Thank you, Mr. Lala. Now, Your Excellency, you have the opportunity to respond. But let me add that if there are any elements of the responses that you want to
yes, I will.
Supplement at a later time,
Yes, yes,
we're still willing to give you 48 hours from now.
Yeah, yeah, of course.
Thank you.
If you think a lot range of issues, maybe it will take one full year, frankly. But as much as possible, we try to summarize our whole debate concerning the most important things that we're trying to answer. But as Madam Chairperson said correctly, that we can convey to you exactly your questions, and we are ready to answer it. Frankly, I want to say one important thing, and it's very important. Quran is a supreme for us. There is nobody can tell us that, you know, this is our religion. And I am member of the United Nations for more than 35 years. Worked in New York, worked in Geneva, worked in so many countries. When I was asked about the minorities, in the Amazon, I was protecting rights of people, rights of religion, everything. I have the right for my religion. And I explained it very well, that my religion does not contradict what international covenants or what international treaties, no. All of us, they work towards one important thing. It's the dignity of human and his civility and his to progress for the future. And we have witnessed it from the jungles when we were, you know, there, till we reached this level in this kind of treaties and treaty bodies. Everybody, we respect all nationalities, we respect all laws. But for us, as a Muslims, yes, Quran for us is supreme. And Sharia is supreme for us. And as I have said yesterday, Quran is not a matter of a religion. Quran is a matter of way of life also. So we try as much as possible to match the two things together, in where we respect our religion, we respect other people's religions, we respect other people's cultures, traditions, whatever, but also we respect international covenants, we respect everything, and we try as much as possible that the two things, you know, we might differ, absolutely we differ. The world full of countries, full of cultures, full of, I was in India as ambassador, and then there is 220 religions, cultures, so many things, and each one they have their own, you know, their own practices, their own, you know. But at the end, there is a supreme law, which is the law of human being, respect, and institutions. That's very important. I will answer my distinguished colleagues here, Mr. Amr, about his interpretation of certain parts, and my colleague there from Egypt about, you know, certain parts of polygamy or you know how many sections in Islam, Mr. Amr? You know how many? You have the extreme right and the extreme left. And you can come to Kuwait and see, not only in Kuwait, see exactly how much interpretations we have. See how much people they are in ijtihadat and a lot of things. You say it, he say it, I say it, they say it. But we try to create a common ground. Your interpretation may be different than our interpretation, different than his interpretation. We have in Islam different sections, different, each one he might come. But at the end, we try common ground. Where we have the most important thing is respect of a human being. There is institutions, we respect them. There is law. But if we enter into what we call ijtihadat, which is wide-ranging. We were stamped for bin Laden. We have nothing to do with bin Laden. On the extreme left, the interpretation completely erroneous and wrong. And to the extreme opening liberalism on the that side, and also they have their own interpretation. And we respect, I mean, except with terrorism, except with condemning, you know, yes, you have to say your rights whatever you want. You can explain whatever you want in Sharia, in Islam, in Quran, your interpretation. And you are very well aware exactly what's the interpretation in Quran. You differ, we differ, and then a lot of people, they differ outside. That's the norm. That's not the, if there is no this diversity, then there is a problem. But am I right for this judgment? You are right for that judgment? Is he right for that judgment? Depends. But again, when we come back, when we said in our constitution, Islam is a source of a main source of for our laws. But we opened the door. We did not close the door. That there are other sources where we can take, which is other laws, human rights, United Nations declarations, it's international treaties, bodies, and all that. But I am sorry if you tell me that certain interpretation has to be put on one people or another. We cannot. And you know it, Mr. Amr, that the interpretation is wide-ranging. It is, you have the extreme right, the extreme left, and we are trying now as a Kuwait, and we're working with our friends in the Gulf Cooperation Council to be in the middle, to try to avoid extreme left, where there is terrorism, where is, you know, you are non-Muslims, you are I don't know what, you have to deserve to be, and again also on the extreme liberalism where we can do everything. No, we are in the middle between the two sections. And you know, if I'm not here to give a lecture about Sharia or to give. It is very difficult to indulge in such a debate right now, you see. But I try to make it clear that Sharia, yes. But as I have said, our Sharia does not contradict from respect of human rights, from implementing of international laws, from, you know, a lot of things. But there are certain things which we think that concerning mirath, which is concerning even an adoption, we move. We try to create a movement towards the future. I will frankly touch on very important point about the Bidun, because this is very, very important. I give, frankly, when I did not want to indulge, I told my delegation, in a debate which is wide-ranging. And frankly, will you excuse me, experts, we have answered some questions, because yesterday, when I left from here, I discovered with my delegation we have answered a lot of questions, which is concerning, but I don't know, maybe, you know, one reason or another was not explained, but I'm ready to repeat them. However, any questions coming to us, we are ready to answer them. Even if they are 11 years ago. We have nothing to, we will debate. But let me assure you, let me tell you one thing. Kuwait is a constitutional monarchy. And there is separation of powers. We have the executive, the legislative, or whatever. Whatever we debate here among you, whatever, to convey it back to Kuwait, it will take, you will never imagine how much it will take it, either from the executive to the parliamentarian, to issue legislatives. From the last time I was with CAT, I'm trying even to put a definition, and I committed myself to a definition of torture, exactly matching the same definition in article of torture in the treaty. You will never, it's 1 year, now almost what? 1 year almost now, 6 months or 8 months. Until there is a long, long procedure in order that we can reach certain paragraph or certain procedure. It's not easy. It is to move the whole government, to move the whole parliament, takes long time, takes very, very long time. Takes bureaucratic sometimes, takes people who can understand, people who can move, people who goes away, people who comes. So it's not very easy. You think that what we discuss tomorrow is going to be implemented or that. Very difficult, very difficult. We can push and push. And frankly, I brought this huge delegation here to listen to you, and you listen to them, so they can go back again there, and then they can engage everybody with the, what we call, with the process of the concerns of international community. What they think about it and what we think about it. And I told Madam Chairperson before I come here, I'm not coming here to a court of justice. And that, frankly, a lot of nations whom they avoid to come to a lot of meetings and experts and presenting reports because they think that people are criticizing them for one reason or that, or for politicizing. No. I think it's a dialogue. And I think a dialogue for the best, and dialogue for where we reach a, at least common, and we can correct it. Whatever we can correct, we can correct. Whatever we can match, we can match. But at the same time, it is not here, I blame you. I came here to poke your eyes or to say this or, to score points. No. This is not our understanding and will never be, you see. And all the time, even my lectures, I say, this dialogue, it's very good, it's very important. We try to come out with the best results we hope to. It's not a matter of, indulging in a scoring points or in, understanding from your parts for our concern is very important. That will encourage us and will encourage other states where we indulge in a interactive dialogue, in a very fruitful dialogue, where we benefit from you and where you can listen to our concerns. This is very important because we have concerns which we think you might take it also in considerations. They told us when we were studying law, when you study law, there is black and white. We say, no, there is a gray area between the two, in which you can at least see exactly what's going on. Frankly, unfortunately, we have done a fantastic job, but we have fought, and we fought since we're young, for the right of women to be elected and to be member of parliament. We fought for it because we think this is the most important thing has happened to Kuwait. One of the most important things. And the first attempt, when we tried, we lost. And we continue to lose. But we never stopped. We continue to press. We continue to press till we succeeded in getting women equal rights, women to be nominated to parliament, women to be, and we are proud, out of 50, Kuwait, I told you, is 1 million people, 6 govern it. We have only 50 members of parliament, 50, 50. And we are proud. And as I've said it in CEDAW, we are proud we have 4 women. And let me tell you, one of the women in the first district, she get the highest vote, because in each district we have 5 major districts beside the government. 5 districts to be elected, 10, 10, 10, 10, 10, 50. And then in that district, one of them, in the first district, I introduced her to the High Commissioner. She got the first numbers of votes. That shows you how much people, they appreciate that, you know, equality and the rights of women, you see. And the second woman, she was, another district, she got the second. Another district, she got the 6 out of 10. And that shows that we are developing in a very, you know, equal society. People appreciate women, people appreciate equality, all this, you see. I will touch base something like very fast. Concerning a judge, woman judge. We don't have it, no. We don't have it. But we are working towards it, like what we are working for the rights of women all these years, till we did it. And we try our best. We try to put women in the highest positions. As a government, we put women out of, as a member as a minister. We used to have before this 2 ministers, 2 minister women. So it is, you know, we are moving in a process where we are engaging, where we are trying to develop, we're trying, you know, and we try the best. But yes, we are moving in that direction. There is a debate, but you have to take also in consideration. You have to take Sharia, you have to take law, to have different sections. You are not working in one section, you're working in different sections. And that's what we are trying to bring, unanimity, or at least consensus in the issue of reaching, you know, concerning major things. I will give only to speak about the illegal resident, Mr. Colonel Wahab, concerning. You have the floor.
شكرا سعادة السفير. طبعا في مشكلة المقيمين بصورة غير قانونية.
With regard to those illegal residents, there is some misconception represented in a general impression that being stateless is the shortest cut to get the Kuwaiti nationality and to enjoy many privileges. So any amendment to this legal status by showing his passport or his nationality, he thinks he will be prevented from enjoying the privileges, and he will have to give up his Kuwaiti nationality. And that is why they are keen to keep their illegal status and suffering the results with the hope of getting the Kuwaiti nationality. They are ignoring the fact that nationality is governed by laws, by the constitution, by security concerns and cultural traditions, and so forth. After independence, the General Authority of Civil Information has tried to count those people and to undertake a census. Before the invasion, the number of legal residents was reduced to 50%, considering the fact that most of them returned to their homelands. The General Authority also discussed and considered all these information with the concerned authorities and the other relevant authorities, and thus we have reached the number of 81,000 from 105 and 700 who have been identified in terms of nationality. Some others have corrected their status. Their number was 16,700, and that was the case before the invasion of Kuwait. Accordingly, this category of illegal residents, and with the establishment of a central organ and having a period of time for 5 years, I believe that this will lead us to reach a radical solution for this problem. I thank you, Madam Chairperson. With regard to the question related to the Bedouin, the stateless persons, as mentioned by His Excellency the Ambassador, they came into Kuwait trying to make a living. But the period of their stay, they hided those passports with the hope of getting the Kuwaiti nationality. So they are illegal residents. They were legal before, but when they hid their passports, they were considered as illegal.
To answer your question, I said they came from a long time ago. But specifically, some of them, they came when I was in elementary school. Some of them, they were with me. And of course, they increased. We did not solve the problem. We did not find solution because, you know, Kuwaitis during that time, they were, in the 50s, they were less than 300,000 people. And of course, the economic prosperity, to move towards economic prosperity, you need human resources. You cannot move without human resources. Even here in Europe, we can see it very well, that to move and expand economic Eurozone, you need human beings. But at the same time, we were developing them, some of them with me, in my school, in my high school, the same school. We have Iranians, we have Kuwaitis, we have Saudis, we have Syrians, we have from all sections, Egyptians, from all, at the same time, same school. No discrimination whatsoever. However, country develops, country expand. They increase, of course. We should have tried to solve the problem. We reached the level, I remember very well, 1988, where we have formed a committee to handle these issues, where they reached during that time around maybe more than 200,000 people with their families in totality. What is the problem? We're faced with a major problem that we know exactly who they are. They were with me. I know who his father, whose mother, whose daughter, we know them. They don't want to reveal their identity. They want to get the Kuwaiti nationality. And you know, I explained yesterday what you can gain from the Kuwaiti nationality. Some of them, we gave them the Kuwaiti nationalities, and a lot, in different sectors, in different, but I mean a lot not, if you compare to the Kuwaiti population. Till the invasion of Iraq, and I want to come to answer your question about the military people. I will answer it. When the invasion happened, you know how many people were in Kuwait during the invasion? Only Kuwaitis. From 1 million expatriates from others, they remained. When I went to India, I was ambassador. There were only 10,000 out of 300,000 during that time. The Kuwaitis, they remained only 200,000. And we are afraid Saddam, he might take them, and then he send them any other place. 200,000, 220,000. And consider 50% of them, they are men and women. 50% of them, they are children, and So how much remaining as adults? Nothing. And that's our main concern in 1990, that Saddam, he might take them to the north, like Kurd, and every other place. Of course, we are grateful to the coalitions. We are grateful to the United States of America. We're grateful for Arab countries, Saudi Arabia, the Gulf, Europeans. We are grateful, and we are lucky that for the first time, mechanism of the United Nations to reverse aggression has been implemented. For the first time, under Chapter 7. For the first time. I read the Charter very well, and I think the Charter is one of the most important documents on earth. With one problem, it's the veto. When we came to reverse aggression on Kuwait, only in one occasion, I remember it very well, we used Chapter 7, and that's when we put embargo on South Africa. This is the only case, never been. And you are very well aware that decisions of the United Nations, three kinds. Recommendatory, which is of the United General Assembly, it recommends. You have Security Council, two types, which is not under Chapter 7, under Chapter 6, which is only uses humanitarian matters. And in the case of only South Africa and Rhodesia, we are implementing that we adopted Chapter 7 and only the embargo on oil section, not only that. We are grateful in Kuwait that we have implemented the Chapter 7. So, when Kuwait was liberated, and I entered Kuwait immediately after that, and we established and we appointed in the third committee in the General Assembly investigation of human rights violation in occupied Kuwait. And it was Mr. Ziegler of Switzerland as the rapporteur to investigate this. Of course, Kuwait is a mess. So many people entered. Iraq brought a lot of people to Kuwait. Kuwait was, I mean, even myself, I almost was killed. You don't know what, it's a mess. And of course, those who came to Kuwait, they stayed in Kuwait. They don't want to go back. Now, we have international obligation in terms of those people that we don't want to use coercive measures or any kind of measures against them. So we went back. Frankly, I tell you, we went back to the countries of the region. We asked them these names and those names. And if you are living in Kuwait, you know your friends, you know your neighbor, you know your tribe, you know your people. Those people, they came, okay, now. It took us time till we established Kuwait. Kuwait was destroyed, completely destroyed. When I entered, you have oil fires everywhere. The production of oil of Saudi Arabia, it reached at the maximum level 11 million barrels per day. Kuwait, it is around 2.5 million barrels per day. Would you imagine when I entered in 1990, the oil fields burning 6 million barrels per day. 6 million barrels per day were burning. It's an inferno. And Kuwait what? Kuwait is 15,000, 16,000 square meters, as big as New Jersey, and smaller than New Jersey. And it's burning. Where to establish the country, to bring everything, to dynamite the whole thing, you know, it takes a hell of work, you see. Those people, yes, some of them, they took advantage, they entered. And then, frankly, I tell you, they have identity, and we have their passports. And we contacted the region. We contacted Iraq, we contacted Syria, and we contacted Saudi Arabia. But they don't want to, you know, we encourage them that we can give you whatever you want. We can, yes, there are people who deserve to be getting their Kuwaiti nationality, and those who were from 1965 or that. And then our people in the committee, they are addressing this issue and trying to reach, you know, a solution within the 5 years. But at the same time, we have to protect, frankly, our demographic situation. We have to, when it comes to nationality, it is sovereignty for us. When it comes to other issues, which is humanitarian things, and we never touch them. And we never, you know, whatever they tell you that, no, I am ready to show you, but we do not want to make it. I will show you exactly their identity. I have exactly their identity. But we don't want to make this a public, you know, this is personal things. We try to solve things, those whom we consider them illegal residents, you see. It is a matter of, for us, is to help them in all levels, but at the same time, they have dual nationalities, dual. And some of them, they turn their passports, you know, you can do it, you go to London, you can, it's England, Europe, but for us in Kuwait, we are very small. From that perspective, we try to help, but we try to solve this problem in 5 years. Yes, I'll come. You were asking me about question number 11. The same thing. When we entered Kuwait, and before we entered Kuwait, it was me who presented, frankly, Mr. Ziegler of Switzerland to be the rapporteur for situation of occupied, the human rights situation in occupied Kuwait. And it was very difficult. And before him was Mr. Van Stoel, we have on the situation of human rights violation in Iraq. And then later on, Mr. Van Stoel, he took over after Mr. Ziegler. So when we entered, you know, he presented his reports. As I have said, Kuwait is a mess. It's you know, we do not know what's going on, you see. And of course, there was recrimination. I have in the third committee in New York in 1990, I have my British colleagues, of course, who helped us a lot, and Americans, and they say, no, there are violations, people, Kuwait, revenge, like what you're hearing right now about the situation in Libya, something like that. So that's absolutely, that's normal in terms of war, chaos, situation, unbelievable, you see. And then us living for now outside Kuwait, and how you can set norms of human rights during where is a revenge happening, where is they killed your sister, your mother, or whatever. So we tried as much as possible to confine whatever we can, you see. But to have tribunals, military, no. We don't have tribunal meetings. We have certain people were attacked, certain people were aggressed. There was some, they told us, and I was here in your committee when I remember very well a colleague of yours who raised the issue from Chile. He raised the issue of, I don't know how many people, 90 or 80 that they were missing. And so I told him, we have nothing to be afraid of. We are ready to let you go to Kuwait, see, investigate, or whatever. And frankly, we are grateful to the International Committee of Red Cross because we have more than 600 prisoners of war and missing persons. And for us, 600 missing persons for Kuwaitis, equivalent exactly for the United States of America, 3 million people, you see. So the issue for us is matter of we are dealing with each and every one of them. No? I will conclude, but I will tell him. So a lot of things came in the Commission of Human Rights before it became a council. And I can give you a copy of this. This is economic and social, where they have presented. I will read only this. And then against us, there were so many cases of abuses, so many cases. And here say, the Commission on Human Rights, having examined the material relating to the human rights situation in Kuwait, brought before it under Economic and Social Council Resolution 1503. And the number is here. Taking note with appreciation of the observation, this is 1994, taking note with appreciation of the observation and detailed information received from the government concerned, expressing the hope that the government of Kuwait will continue to take positive steps for the promotion and protection of human rights in the country. Then the operative paragraph decides to discontinue consideration of the matter. Requests Secretary General to communicate this decision to the government of Kuwait. It means we presented our case. And those allegations about us, we came to the Commission of Human Rights and we pleaded to the Commission, and the Commission gave us this. And I'm ready to give you a copy of it. Thank you, Madam Chairperson.
I thank you, Your Excellency, for your extensive responses. But it appears, ladies and gentlemen, that we will not be able to cover the second half of our list of issues within the allocated time at this point, because we've only got just less than an hour and a half. But in order to help us along, I'm going to ask members of the committee to be as concise as possible when they pose their questions from 19 to 36. And I begin...
Madam Chairperson, and can we answer it later? Written, whatever we can send written?
Yes, certainly, Your Excellency. We do have the practice of giving delegations 48 hours to respond to whatever issues they did not have time for during the dialogue.
And frankly, I would like, I'll appreciate it if distinguished experts, I will let my delegation approach you to take your questions if you, I try as much as possible, but I want to take as much as possible from them with the major questions, and then I will ready to respond to them, if you don't mind.
Thank you, Your Excellency. We'll certainly allow you and your delegation to send us written responses within 48 hours if we do not complete the second round of discussion and dialogue with your delegation. I now give the floor to Mr. Flaherty.
Thank you, Madam. And since this is my first time taking the floor, may I rather belatedly welcome the distinguished delegation and thank it for its engagement with this dialogue, which is very valuable. Madam, if I could just briefly refer to the point that we're running out of time. Of course, the fact that we're in the second half of the list does not suggest that the second half is any less important than the first half. And I do think it's important to find the time today for as as substantial as possible a putting of our questions and an initial, at least, response from the delegation. If I may turn now then to question 19, which refers to the matter of a draft law on obligatory military service. The answer provided by the state party contained in paragraph 84 of the responses really doesn't tell us anything at all. It's one line, about 9 words. The National Act is tabled before the Assembly. I'd be very grateful if the delegation could actually answer question 19 and give us some elements of information regarding whether it is envisaged to allow for conscientious objection to military service. While responding to that question, it would be very helpful if the delegation could inform us as to whether any of the proposals that were being debated in the state party in 2008 are still on the table for consideration. For example, I understand that while the matter was in front of the Legal Committee of the Ministry of Defence in November 2008, there was a proposal that every Kuwaiti citizen aged between 18 and 35 would be obliged to enlist at the nearest military office. So some information on the content of the proposed law and the space for conscientious objection would be helpful. And finally, with regard to issue number 19, I have seen some matters that were put to Kuwait by the Committee on the Rights of the Child. And I'd like to raise them again here to get a sense from the delegation as to whether there is indeed a problem that needs to be addressed. The Committee on the Rights of the Child asked the state party what safeguards it had against the recruitment of children, especially street children, into private security companies. So it would be very helpful to get a response on that matter. Turning then to issue number 20, here again the response in the responses at paragraph 85 is very brief indeed. There's no answer at all to the second question we put in issue 20, which was to provide information as to whether conversion from Islam to another religion may result in the loss of Kuwaiti nationality. So I'd be most grateful if the delegation could answer that question that was put in the list. And in responding, could they please comment on an NGO report before us to the effect that recently the Kuwaiti Court of Cassation upheld a lower court decision not to allow a 27-year-old citizen convert from Islam to Christianity to change his stated religion on his birth certificate. Because if it were to allow the birth certificate to be altered in this manner, it would constitute a violation of the apostasy laws. And so if the delegation could help us on that, I'd be very grateful. Moving on then to issue number 21, where we requested information as to how many non-Muslim places of worship are licensed to operate, and where we asked for a list of officially recognized religious institutions. We've got no answer at all. The written responses jump from the answers to 20 to the answers to 22. There's nothing on 21. So could the delegation give us an answer on that matter, please? And while responding, it would be helpful if they could comment on the pretty widespread, independently sourced pieces of information before us, indicating some difficulties around this issue. For example, one source before us says, and I quote, that non-Muslim religious organizations have had difficulty operating due to registration requirements. The government did not recognize some Christian churches, and those churches could not operate openly. Some recognized churches complained that their quota of visas did not meet their needs for clergy and other staff. The quote continues, Shia faced some disadvantages in comparison with Sunnis, and members of religions not sanctioned in the Quran, such as Baha'i, Buddhist, Hindus, and Sikhs, may not operate official places of worship at all. So let me leave that quote there and simply request that the distinguished delegation comment on whether indeed it does represent the actual situation. And then moving to question 22, in which we asked whether non-Muslim pupils are obliged to attend classes where Islam is taught, and generally information as to whether non-Islamic religious education is allowed in either public or private schools. I'm grateful for the answer on this contained in paragraphs 86 and 87. I have to say, though, and this may well just be a matter of the translation, that I remain unclear on the situation. And I'd be grateful if the delegation could confirm the situation with regard to the following couple of points. Firstly, what is the situation with regard to Kuwaitis who are not Muslim? Must they attend religious education in the Islamic faith? I simply don't understand the situation in this category based on the response before us. So non-Muslim Kuwaitis. Secondly, what is the situation with regard to non-Muslim non-Kuwaitis? I think I understand from the response that they do not need to attend Islamic religious education. I'd like that confirmed. And finally, could the delegation inform us where non-Muslims can be taught in their faith? In what context does the state make provision and space for the teaching to non-Muslims of their own faith? And is it possible at all in any schools? I ask these questions, of course, as with all of our questions, because of the very clear issues arising with regard to, among others, Articles 18 and 24 of the Covenant. Turning to issue number 23, I'm moving on to another topic, which is broadly that of defamation and freedom of expression. Let me say by way of introduction that there does appear to be a problem around the space for freedom of expression, and particularly journalistic freedom of expression in the state party. The state has very helpfully provided us with statistics. They were in Arabic, but again, thanks to Mr. Newman and I imagine his colleagues, I've been able to look at a translation of the annex, and by any measure of reading, it indicates a problem. The extent to which the courts are used to limit journalistic freedom of expression is remarkable. In a country of, 3.5 million people, in 2005, there were 371 complaints registered in the courts regarding publication and generally media alleged violations of the law. That's an extraordinary figure. Even if every single case were a legitimate one, I think the statistics indicate a general problem in that regard. And I'd be grateful for the observations of the delegation in that regard. They might also take the opportunity to comment on figures which an NGO has provided for 2010, in which apparently there were 678 complaints regarding alleged abuses of expression, not just by journalists, but more generally in the context of such crimes as lèse-majesté, critical remarks regarding tribunals and so forth. So a better sense of restraint on freedom of expression in the state party could be very usefully provided to us by the delegation. Could I also ask that in responding around these issues, the delegation advise us on the current status of Mr. Mohammed Abdul Qadar al-Jassim, a journalist and lawyer who was the subject of repeated expressions of concern by the UN Special Rapporteur on freedom of expression, the chair and rapporteur of the Working Group on Arbitrary Detention, the Special Rapporteur on Human Rights Defenders, and others. So what is the current situation in this case, which has achieved a very high degree of international notoriety, please? And finally, on issue 23, may I draw to the distinguished delegation's attention the very recent finalisation by this committee of a new general comment on freedom of expression. It's general comment number 34, which lays out in extensive detail, 52 paragraphs of detail, the importance of freedom of expression and the very limitative scope within which states may legitimately restrict freedom of expression. Because on the information before us, it does appear that the limitative scope on this right in Kuwait is excessive and incompatible with Article 19 of the Covenant. My last issue relates, Madam, to question 24. I don't propose to raise any matter on issue 25. So just on 24, and again around issues of media expression and particularly censorship of internet communications, again we seem to have before us a rather worrying situation. In the first place, I refer to the response given by the State Party at paragraph 90 of the written responses. And again, I suspect we're dealing here with just a translation problem. But in the English, the impression is given in paragraph 19 that telecommunications equipment may only be used lawfully when it's authorized by the Office of the Public Prosecutor. Now, I think that's a mistranslation. I think that the reference there is actually just to telephone tapping equipment, in which case it's perfectly understandable. But I'd like that clarified. Is it indeed the case that telecommunications equipment, use of such, would be criminalized without consent of the state? Again, I don't think that's the issue. I think it's a translation matter. But secondly, I'm worried by independent information before us, which reads as follows. Again, I'll quote the independent information. According to the International Telecommunication Union and its statistics for 2009, the 39% of the country uses the internet. However, the government monitors internet communications for defamation and security reasons. And in this context, the Ministry of Communications continues to block websites considered to incite, among other things, instability, and requires internet service providers to block religious websites that violate Kuwaiti customs and traditions, and so on and so forth. And again, if that indeed were the case, as it's just been indicated, it would go considerably further than is permitted under the Article 19 and our new general comment, in which we remind state parties that restrictions to the freedom of expression should be the exception and not the norm. And I'd draw to the distinguished delegation's attention, I won't read it because time is short, I draw to their attention paragraph 43 of the new general comment, which expressly makes clear that the new communications media are subject to the same freedoms and the same very restrictive, limitative scope as the more traditional media that have been heretofore discussed in the context of freedom of expression. I very much look forward, Madam, to receiving the responses of the distinguished delegation, and I conclude again by thanking them for this very helpful exchange of views. Thank you.
Thank you, Mr. O'Flaherty. Like you, I do want us to have a balanced dialogue between the first and second set of issues. And so it will be useful to take advantage as much as possible of the presence of the delegation here to respond as much as possible to our questions orally before you provide us your written responses. And so
will give us some time.
We shall see, Your Excellency. We might want to extend this dialogue because indeed we want to benefit from your presence here.
Okay.
And so we'll see how it goes. But for now, I give the floor to Mr. Bouzid.
Thank you, Madam Chairperson. At the outset, Since this is the first time I take the floor, I wish to warmly welcome the large Kuwaiti delegation, and I particularly welcome its composition, which is proof that Kuwait takes seriously its compliance with its commitments. Madam Chairperson, I wish to deal with questions 26 to 30 and 35 as well. Regarding question 26, in your reply to this question, you said that following the ruling of the Constitutional Court, that the public assemblies were considered unconstitutional, and therefore there is now a bill amending provisions of this act, and it was transmitted to National Assembly on the 4th of February. I would like to know whether this was adopted, and I would like to know what is the content of that bill, which concerns a very important matter for the situation in Kuwait. The information that we have received from various sources and reports, as well as NGOs, have confirmed to us that Article 12 of Act number 56 of 1979 refers to public assemblies and gatherings, and that it is contrary to Article 44 of the Constitution, and that security forces in many cases, according to these sources, have prevented non-Kuwaitis from taking part in these public assemblies that were organized by Kuwaitis in support of Arab revolutions. And according to the same reports, many cases have been proven that security forces have attacked peaceful gatherings. Certain demonstrators were attacked and were beaten. Dr. Jam'an al-Harsh was also beaten, according to the reports. And this happened on the 8th of December 2010. Many of the demonstrators, in fact, were injured, including a professor in the University of Kuwait Faculty of Law, Mr. Abid al-Wasmi. And when this person, in fact, sued the Ministry of Interior, he was arrested and he was charged with many crimes, including fabrication of information and defamation and lèse-majesté. And this person was released only 4 months after detention and after having paid bail. According to the same reports, security forces have also stopped gatherings and demonstrations by bidoons, or stateless persons. Excessive force was used against them, although these gatherings were peaceful. They were attacked with tear gas, with beatings, and some of the demonstrators were arrested and accused of certain charges, and they were detained and treated in a very cruel manner. This is what is contained in the reports that we have heard, and we would like the delegation to comment on these allegations. Regarding question 27, you mentioned in your second periodic report that there is a new bill before the cabinet regarding benevolent clubs. We would like to know what is the situation of this bill. It seems that this bill cancels or repeals law of 1996, which was amended pursuant to Act number 12 of 1993. Regarding this Act number 24, 1962, regarding the right of foreigners to join trade unions, it was you said that there is nothing in the law that prevents non-Kuwaitis from joining trade unions. This is what you said in your reply. However, according to the information that we have and that we receive from various sources, as well as non-governmental organizations, including NGOs inside Kuwait, it is said that the joining of trade unions is according to certain conditions, especially the issuance of a certificate of good morals. And out of 2 million workers, only 100,000 worker is a member of a trade union. Moreover, only one trade union can be established in any particular sector of activity. The trade unions that are not members of the Kuwaiti Federation of Trade Unions, these trade unions will not benefit from the subsidies and the support provided by the government. It also seems that domestic workers and workers in the marine sector are not allowed to join trade unions. Foreign workers do not have the right to vote or to be elected to a trade union position unless they have resided in the country for more than 5 years. Therefore, my question is, what is your comment on these allegations contained in the reports that we have received? Regarding question 29, in paragraph 170 of the second report, is that law 24 of 1962 does not restrict civil society organizations or the setting up of such organizations, and it seems that in 2007, 71 NGO was set up, 6 of which are concerned with human rights issues. However, according to the information we have received, this Act 24 of 24 provides the government with vast powers regarding the licensing of the NGOs and controlling the management committees of the NGOs. The membership is restricted to Kuwaiti nationals only. And according to the same reports, the government, in fact, refuses most of these applications. In 2010, 149 NGOs are still awaiting licenses. And you also mentioned in your replies to question 29 that an NGO which did not receive a license can appeal the decision before the courts. And my question is, what are the reasons that justify the refusal to issue a license to an NGO? What is the number of NGOs who have not been granted a license? What is the number of NGOs who have appealed the refusal of these licenses? And what is the number of NGOs which have been able, after having appealed the decision, have been able to receive a license? Please provide us with clarifications on this matter. Regarding question 30, related to the right of Kuwaitis to set up political parties, your reply, and I hope that I am mistaken, your reply does not seem to be very clear. This reply does not negate that, and neither does it confirm it. The reply is quite ambiguous. The interpretative declaration of Article 43 of the Constitution mentions expressly that the Constitution does not allow for the freedom or parties, nor does it restrict such establishment. Does that mean that Parliament can issue a law which allows Kuwaitis to set up political parties? And if that is the case, what are the reasons that would prevent Parliament from enacting such a law, especially a law which is extremely important for any democratic society? Finally, regarding question number 35, and I would like to recall the concluding observations mentioned by Mr. Lala. Question 35 is related to minorities. In issue 14 of the concluding observations in 2003, when you presented your first periodic report, the committee said that it was not able to accept the statement of the delegation of Kuwait, meaning that there were no minorities in Kuwait, and that there is a great diversity in the society, in the Kuwaiti society. It is quite clear that there are many national, linguistic, and religious minorities in Kuwait, and therefore their rights must be protected by virtue of Article 27. This is the reply that we got from the delegation on issue number 14. And the state then was requested to present at its next periodic report full information regarding the minorities, which are governed by Article 27, which Kuwait is bound by. And in fact, you did not reply at all to this question. Therefore, my question is, you have not replied to this question. Is Kuwait ready to recognize the existence of minorities and their linguistic, religious, and ethnic rights? Or is Kuwait still insisting that there are no such minorities, although the committee insists that due to the diversity and of Kuwaiti society, and the fact that there are more than 2 million foreigners in Kuwait, there are minorities. Therefore,
أنا فقط هنا أكرر، يعني في الحقيقة أكرر، أحيلكم هنا إلى قراءة الفقرة 14 من
Sir, I would like us to return to
اللجنة في جويليا سنة 2000. سوف تجدون هذا الكلام.
You have found everything that I quote there.
فقرة 14 سوف أنا فقط أنقل ما قيل في الفقرة 14 فقط.
Please reread the paragraph. Please reread what was said in the paragraph. And I'm asking why there were no responses from your part, especially when we heard from you that you would present details on all these subjects. Therefore, you fully have the right to clarify to us on the issues which remain ambiguous. Thank you.
Thank you very much, Your Excellency. You'll get your opportunity in a few minutes, in a couple of minutes. I just want one committee member to pose questions. Mr. Flinterman.
Thank you, Madam Chair. My questions today will be based on the issues 31 to 34 and the replies thereto by the State of Kuwait. The first issue relates to the legal age of marriage, which is 15 for women in the State of Kuwait and 17 for men. We have received information which indicates that in some tribal groups in the State of Kuwait, girls and boys are married even before the age of 15 and 17. And my first question would be, if that information is correct, measures is the government of Kuwait undertaking to prevent such marriages? Second is a very factual question. Although the law provides for a minimum legal age of 15 and 17, what is the average age of marriages in the state of Kuwait, both for women and men? Third, in this context, a girl of 15 and a boy of 17 are still children, according to the definition of a child in the Convention on the Rights of the Child. My question, that's the third question, is what obstacles does the state of Kuwait see to amend its legislation in such a way that the age of majority for both girls and boys is equal and is also serving as the legal minimum age for marriage? That's 31. 32, in the English version of the answers to the list of issues in question, there is no reply to question 32. And I take it that that is an oversight. For that reason, I'm reading the two questions in 32. The first is, are legislative amendments foreseen to enable Kuwaiti women married to non-citizens to pass their nationality on to their children and spouse? That point was also raised very briefly yesterday afternoon, but no answer has been given so far. And I would appreciate an answer to this very important issue of the equality of both women and men in Kuwait to pass their nationality to their children. And the second question is under 32 is more general. Please provide detailed information on the differences between the Code of Personal Status and the covenant rights in all matters pertaining to marriage and divorce. And bits and pieces of that question have been put forward in the context of yesterday's discussion. But still, it would be important for our committee to have a full survey of the differences between the present Code of Personal Status and the covenant rights in the important matters of marriage and divorce. Issue number 33 relates to the problem of corporal punishment, and I'm very pleased with the detailed answer by the government of Kuwait, from which it appears that in the context of education, corporal punishment is illegal. Nevertheless, if such corporal punishment would take place, my question would be, who can complain and what remedies are available? But in issue number 33, there is also the point raised of corporal punishment in the context of the home and alternative childcare institutions. And I would be very much interested to know whether also in that context of the home and alternative childcare institutions, corporal punishment is illegal, and what sanctions are available in such situations. And then finally, we are informed that in the context of the prison regulations, corporal punishment has been outlawed, has been prohibited. And again, my question would be, if it would take place, what complaint procedures would be available to the prisoner and what sanctions can be imposed? And then finally, Madam Chair, that is issue number 34, relating to the very important issue in the context of the state of Kuwait of migrant domestic workers. That is an issue that has been raised also yesterday. And we have been informed that presently domestic workers fall within the scope of the General Labour Act. A reference has been made, I think, in the context of the replies also to a pending law, a draft law on domestic workers. And I would be very pleased to hear from the delegation more precise information on the contents of that law, and whether that law addresses such burning and important issues as the withholding of the passport by the employer, such as the issue which was also raised, the withholding by the employer of a contract, And I would be very much interested to know the sanctions that can be imposed in such situations. And equally, I would be very much interested to know whether this new law on domestic workers would create an easy access to the judiciary and to other remedies. And finally, in this respect, I would like to know, given the urgency of the matter, what the time frame is for the adoption of this draft law on domestic workers. Those were my questions under 31 to 34, Madam Chair. And like yesterday, I'm looking forward to the reflections of the delegation. Thank you.
Sir Nigel, you have the floor.
Thank you, Madam Chairperson. This is a brief intervention of a legal nature. This is a brief intervention of a legal nature to help orient the delegation in the kinds of responses that we'd appreciate in order to be able to do our job properly. The International Covenant on Civil and Political Rights is an instrument of international law. It is axiomatic that no state can invoke its own national law as a way of avoiding its responsibilities under international law. It is not of any concern to me what aspects of its national law may or may not, to us indeed, may or may not be in conflict with what other aspects of national law or with the International Covenant or any other international treaty. The covenant is the covenant. We have to apply it. I don't particularly appreciate hearing that it's just one factor amongst others that the state of Kuwait has to juggle. The state of Kuwait is bound. It has, by its own act, its own solemn act of becoming a party to the covenant, by the provisions of the International Covenant on Civil and Political Rights. And if the delegation could now concentrate on explaining, in response to the questions received, the extent to which it accepts that the national law or national practice does or does not comply with the covenant, because that is what our colleagues, all of us, are asking. It would really facilitate the dialogue that we're seeking to have with the distinguished delegation. Thank you, Madam Chairperson.
Thank you, Sir Nigel. As is our usual practice, we'll break and give the delegation 10 minutes to prepare responses to this second set. But the Ambassador wanted to respond briefly to Mr. Bouzid on a matter that he wanted clarification on. Thank you.
Thank you, Madam Chairperson. Frankly, I wanted to elaborate on about ethnic we have in Kuwait. Frankly, I was repeating it and saying it in a lot of fields. As I've said, 1 million. Kuwait was since 300 years ago. We came from different parts, Saudi Arabia, Iraq, from Iran, but now we are 1 million. We don't have, frankly, ethnic per se, and that's what we are explaining a lot of people, that we do not have ethnicity within. And then if we go and try to dissect the society, then this will create a big problem for the society. Never. So we have one term, that we are Kuwaitis. We have no other, like other maybe big countries or whatever they have from different regions, but we have one term, that we are Kuwaitis. And we try as much as possible, this mingling, being together and mixed together from all sections, we have only one. And that's according to the law, that we are only Kuwaitis. We don't have any, frankly, yeah, we have people, contractual laborers, we have from different countries, we have from, that's different. But as say Kuwaitis, we don't have. Only Kuwaitis mingle together, they live together, and then we are one single people. We don't have those from this section, this from this section. let's try to make it a clarification. And I'm ready to answer it, even written for my distinguished friend here.
Thank you, Your Excellency. We'll take a break. I suspend the meeting for 10 minutes, and we should be back here just after 12:25. Thank you. Ladies and gentlemen, we resume the dialogue, and I immediately give the floor to His Excellency, the Ambassador, to proceed with the responses.
I'm very clear in our position that international treaties, they are part of Kuwait legislation. We're not saying, they are part of our legislation. They are part of, and the international treaties, and the covenants, they proceed over the national law. This is our position. We did not. But in certain aspects, when we raised to Sharia, we explained what is our position of Sharia, that we have certain things that we are abide by Sharia, certain sections. But absolutely, I make it very clear to everybody that international covenants, international treaties, international law, international humanitarian law, international human rights precedes over our national laws, and it becomes part of our laws. But we have certain sections like for Sharia or that, and we are not juggling here and there from one section to another to hide or say anything. No. International law, it has precedence over our own laws. But there are laws within, had been long time been ensued before Kuwait and after Kuwait and after the establishment, and then you need times to adapt it, you need times to that. But absolutely, let me make it clear to the distinguished experts here that yes, international law has precedence over national law, and we are part of that. And that's commitment we made, and we are abiding by it. I'll start from the questions in the back, so I will go up, and I hope my delegations will answer it. Concerning the passport, because we answered it yesterday, but I don't mind to answer it again. Dr. Zeki, concerning immediately about the passport, confiscation of passports. And
بسم الله الرحمن الرحيم. كان أحد الأسئلة.
Thank you, Madam Chairperson. Among the questions raised by the distinguished activist on the law that organizes domestic workers, this was what the expert asked, whether there is a draft law that would stipulate the withdrawal of passports from the domestic workers. Actually, this kind of conduct is in contradiction with one of the provisions of the Constitution, namely to restrict his right to free movement. And of course, withdrawing the passport will have this impact. With regard to whether he is a domestic worker or whether he is working in the government, the passport should never be withdrawn, and the court always the courts make judgments to the effect that these passports should be returned to their owners. This has to do with a constitutional principle. I thank you.
Punishment of children. But please, it's so fast because we.
بالنسبة لتقديم معلومات مفصلة.
With regard to the further information on corporal punishment, my answer is that the state of Kuwait criminalized corporal punishment in accordance with Article 160, 161, 162, and 164 of the Constitution. And the legislator never allowed the corporal punishment for children. And if it is perpetrated by the teacher in a school, then the perpetrator is prosecuted in accordance with Article 56 of the Criminal Code. And in Law Number 3 for 1983, there is a provision that says that that a child should not be subjected to corporal punishment, and that there should be no punishments that would deprive them of their freedom. Article 38 regarding juveniles states that juveniles should not be subjected to psychological or corporal punishment. With regard to Article 98, the technical authority and the shelters for girls and boys should have self-restraint when dealing with such cases. With regard to good morals and conduct, those children should not be made fun of and should have the freedom to dialogue. The corporal punishment is not allowed at all, as it contradicts with the proper upbringing of children, and that is why we have educational programs on how to bring up children for families, for schools, and they are being disseminated through seminars and workshops. In the Ministry of Education, in its regulations, it stipulated that no corporal punishment should be used or any insults and that they should be dealt with in a calm way, and the punishment should be in accordance with the proper disciplinary measures.
Of laborers,
Bismillah ar-Rahman ar-Rahim.
With regard to the draft law or the draft bill that is being submitted, we have asked several institutions of the civil society to take part in drafting and in formulating this bill on domestic workers. and there have been some recommendations, but with regard to confiscation of passports, we have a contract that prohibits the employer from confiscating the passport of the domestic worker. And there have been many judgments made with regard to confiscation of passports. And through such judgments, the plaintiff could get civil compensation. With regard to retention of workers inside the house, or if they are held up in the house, actually we explained that there is a special quarter for the domestic workers. The domestic workers are taking weekly holidays, and if there are extra working hours, they should be paid for overtime. With regard to access to court, access to court is available to everybody, be they domestic workers or otherwise. They could take the necessary measures, and they could have legal counsel. With regard to the deadline or the period of time necessary for the law, according to the law, of course, this bill takes its time until it is ratified by the legislative authority, I think.
Question of the woman can her children, ask question number 31. Okay, بس بسرعة سعاد الخليج. Quickly.
فيما يتعلق
with regard to giving the Kuwaiti nationalities for the children and the husband of a Kuwaiti woman, the state of Kuwait had made reservations regarding granting citizenship to her husband, but for her children it was allowed, whether they've been born inside or outside the Kuwait, and if the father is well identified, the third case, when the husband dies, or the fifth, if the father is detained or held as a prisoner of war, in those cases they do not.
Concerning.
They grant the nationality.
And then the allowance, and then how do you?
Thank you, Madam Chairperson. Thank you, Ambassador. With regard to the establishment of political parties, the question was posed on the grounds that political parties, according to the Constitution, did not stipulate the freedom of establishing political parties. But the interpretation of the Constitution indicates that this does not mean that the establishment of political parties are not allowed. The legislature may provide for the establishment of the political parties. They are not prohibited accordingly. Some members of the parliament submitted a bill regarding the establishment of political parties. that is in cooperation between the legislative and the executive authorities, and hence the Speaker of the Parliament submitted a draft on this proposal, and a commission was created composed of officials from the Ministry of Interior and all relevant ministries, and they looked into this proposal and they concluded that the Constitution does not really give the right to establish political parties, but at the same time it doesn't prohibit it. So the legislator has the right, and he may establish such political parties. There are no constitutional impediments that would hinder the establishment and the creation of political parties. Thank you.
Number 29 that's non-governmental organization concerning the supervision of allowing giving governments.
Thank you, Mr. Ambassador. Thank you, Madam Chairperson. There have been several questions raised by one of the distinguished experts on NGOs with regard to obtaining permissions for NGOs that have a permit or with no permit. With regard to the first question, with regard to the non-issuance of permissions to NGOs, this might be due to some reasons related to the non-completion of the necessary papers. Secondly, sometimes the objective of the NGO are in contradiction with the public interest. And with regard to those NGOs that have been permitted to work, and in accordance with Article 27 of Law 24462, they have to have, they could be dissolved, and they could go to court. And we still have a case with regarding a doctor, and it was appealed at the administrative court in accordance with Law 24/1981. As for the number of NGOs until 2011, it was the number is 80 NGOs, but and the number of those that have not been yet announced and declared official is 39.
Detail of
الرحمن الرحيم بالنسبة إلى السؤال الخاص ب
With regard to the question related to the restrictions imposed on non-citizens with regard to trade unions, these restrictions are contained in Law 38/1964, but they have been. This law has been repealed by virtue of Law number 6 of 2010. This new Law number 6 abolished all restrictions related to the joining to trade unions. Every non-citizen can now join any trade union, but it has to be in light of the statutes of this trade union or that trade union. But this has nothing to do with the non-approval or whether that has nothing to do with the fact of being Kuwaiti or non-Kuwaiti. Lastly, The new labor law, number 6, 2010, that has to do with civil society. It has been laid down in cooperation with the ILO, and it was approved particularly with the creation of trade unions. I thank you. With regard to question number 26, which has to do with the public assemblies and gatherings, there was a question related to whether or not this has been ratified by the parliament. The answer is no. But out of our firm belief in the fundamental freedoms according to the Constitution, no member of the security forces could attend such public assemblies and gatherings. The public assemblies and gatherings are allowed in light of the conditions stipulated by the law, provided that the subject matter of such assemblies should not be in contradiction with the public safety and security. These gatherings should be peaceful and should take into account the public morals, but after the Constitutional Court abolished Article 1 and Article 4 by law number 65 contained in law 65 of 1976, because there was a prohibition and the exception was to allow such gatherings. And there have been a new law that was submitted to the Parliament, and now the principle is to allow such gatherings and not to prohibit them. There are certain rules and regulations that have to be observed. For example, the governor should be notified of such gatherings, and that is on the grounds of maintaining the peace.
And especially in Diwan al-Harbish and Abeid al-Wasmi, if you can, please, because you were part of that, I think.
Yes.
Okay, please go ahead.
ما حدث
With regard to the Diwan al-Harbish, I was there. They never took and they never notified the governor, and they never took permission. So we received many complaints about traffic, and that is why they were throwing stones and shoes, and we were trying to control the situation, and I was aggressed. I personally was aggressed, and this is the proof. And this is a compensation that I was granted as a result of this aggression.
It's okay. We can write it. Quickly on the Saud, you have 23 with 24 concerning the freedom of expressions and the internet. Huh? What are the laws? لا التعبير. This is the most important thing. Yeah, the right of expression, please. You have a minute.
If I may ask our interpreters before you proceed, madam, to please bear with us for the next 5 minutes. We hope to have finished by then. Thank you.
Freedom of expression, please. And the rest we will supply them written for Your Excellency.
At the outset, and regarding the judiciary, the Constitution and the law guarantee the independence of the judiciary and guarantees the integrity and probity of the judiciary, as well as the safeguarding of all human rights. Regarding the executive authority and its relationship with the Supreme Judiciary Council, the Minister of Justice is allowed to attend the meetings of the Supreme Judiciary Council, and neither he nor his assistants may vote on the decisions that are adopted in the Supreme Judiciary Council. As to the foreign judges, they are appointed by virtue of a decree after having consulted the Supreme Judiciary Council. No such decree of appointment can be issued without the approval of the Supreme Judiciary Council. And as to the contracts with the foreign judges, they cannot be concluded unless the Supreme Judiciary Council has approved these contracts. Regarding certain foreigners in the judiciary, these are basically experts, specialists, highly qualified persons, and some of them have been seconded and those who are responsible for any judiciary matters are all equal before the law.
I see there's a member of the committee who wants to take the floor. You have the floor, sir.
Thank you, Madam. I'm just taking the floor to plead with us all not to continue in this way. This is pointless. We're going at such a speed. We're not having a dialogue. It's nobody's fault. But I think it disrespects the delegation and the important issues. And my request is that the delegation would be kind enough to come back for perhaps an hour this afternoon so we can do this job properly. Thank you.
Thank you, Mr. Flaherty. I have asked the head of delegation, the ambassador, if they would like to come back this afternoon, but he preferred to finish at 1 o'clock. That is the response. But I don't know if you want to change your mind, Mr. Ambassador.
If the committees would like, we are ready to come back. We have no problem.
Please, then your delegation can continue then after 1 o'clock.
But we repeat again what we have said. I mean,
well, to respond to the rest of the questions that you haven't had time to fully explain to members of the committee.
Okay, no problem.
So we break for lunch and come back to the room at 3 o'clock.
Okay.
And hopefully for 1 hour.
Only 1 hour?
Hopefully.
Okay.
If the dialogue can extend that long.
No problem.
Thank you very much.
No problem.